Thank you, Gayatri. Good morning to one and all present here. With great pleasure, I am pleased to introduce Dr. Srinath Naganathan, Assistant Professor in Biotechnology, Department of Sciences, St. Mary's College, Secunderabad, Telangana, India. He has completed his doctoral research in the field of microbial biotechnology from Techno Global University, Shillong, Meghalaya. His research interests include agricultural, environmental, and microbial biotechnology. He is an inspiration for students by his active research and has motivated them to complete 6 major research projects, among providing guidance for various projects to postgraduate students. He started his professional career as a research coordinator in the Department of Microbiology at Asian Institute of Gastroenterology, Hyderabad. He then served as an assistant professor in Konganadu Arts and Science College, Coimbatore, and has around 10 years of teaching experience. Added to his credentials, he played a pivotal role as mentor and member under the DBT Star College Scheme, Department of Biotechnology, Government of India, New Delhi for various colleges. He is also a member of various professional bodies. He served as member secretary in Institutional Committee for Stem Cell Research, ICSER, ICMR, Prasad Hospitals and Prasad Research Foundation. He serves as a member of American Society for Microbiology and holds life membership in Indian Science Congress Association. He has published many international research articles and authored chapters in 5 books. He has presented papers in many international conference proceedings, both in India as well as abroad. He has expertise in organizing various workshops to infuse the skill-based training among students and research scholars. His technical expertise in molecular biology and biotechnology has enthused students with the responsibilities to carry out various research activities in genetic engineering and immunology and motivated many students to imbibe their research pursuit. With this brief introduction, I now invite you, sir, to take over the session. Over to you, sir.
Thank you, Dr. Amli ma'am and Dr. Shivaranjani ma'am for organizing this workshop. I also thank Dr. Balamurugan sir and the management of DG Vaishnava College for inviting me for this workshop. So, taking on to the subject, can I present, ma'am? Can I share the screen?
Yes, sir.
Okay. Just a minute, I will just share my screen. So before going into the topic, I just wanted to make it clear that the IPR, that is the Intellectual Property Rights or the Indian Patent Act in India, it all started during the period of Britishers. Why I'm saying this in this particular scenario is, the main aspect, what happens is, when Britishers were ruling our India during the 1856, we will see the history and other things here. But during the period of 1856, this is a very important period. Why? Because the first independence war took place in 1857. But in 1856, at that time, many new products were introduced from the foreign land, that is from Britishers' land to India, like clothing, it can be cartridges for the bullets, many things were introduced. So the patent law also came along with that, but in a disguise. Why I'm saying in disguise is, people were not aware at that time what is patent. So we will go into the topic. So this particular topic of intellectual property rights basically depends on two, and many aspects are there, like the copyrights and other things. But intellectual property rights is basically dependent upon your mind. Why I'm saying mind is, the product, whatever you are getting into the market, it is based on your creation. Once a person's idea comes out in the form of product or any kind of creation, you can apply for intellectual property rights. That is your right. It is the different from the properties in terms, because it is intangible, because it gives you many different kinds of advantages if you are having a patent or any other kind of design, or it can be circuits or anything like that. Hence, it is some different way. You can say for the protection aspect, it is very much important for the country and for the person. If you see the intellectual property rights, it is combining of the body of law developed to protect the creativity, or you can say the creative people who have disclosed their invention for the benefit of mankind. So if someone copies your work, what will happen? The basic difference is when someone copies your work, you will not get any kind of royalty then. So to protect or safeguard your rights and your product or invention, this intellectual property rights come into the play and helps you to protect your and safeguard your creation. So in detail, what we can say is in different examples we can take, like film or musical composition and invention or brand name, anything it can be. So in this aspect, if you have an intellectual property rights, that is over any of your work or idea, then you you have the rights, and if anyone want to use it, they have to take the permission. See, for example, a movie came on the basis of Milkha Singh. So for that, they have to take the permission from the particular person, and then only they can make a movie like Bhag Milkha Milk. So in that aspect only, this intellectual property rights actually gives you an idea to protect and gives you a monopoly, you can say. If otherwise, you can initiate a legal action against a person if someone copies your work. You will get the benefit out of it in any form, like royalty, or you can say like an remuneration or amount, or any form of rewards also you can get based on the intellectual property rights. So the work either can be artistic or it can be commercial. So as I said, it is having different kinds of divisions in this. So the commercial ones also known as the industrial property rights, and these are ruled based on the copyrights, trademarks, patents, industrial design rights, and trade secrets. So the copyrights basically it deals with the books. If any of your books, if you see, there will be some publisher will be there and some author will be there. So the person, if they make this book and they publish it with some of the publishers, what will happen is they will get the royalty income out of it. The same happens with the music or software or painting, etc. The same way, the industrial property rights also is created and mainly for the industrial aspect or commercial purpose, basically, you can say. So in that aspect, if we go forward, patent plays a very important role in this aspect of commercial scenario or industrial scenario, because patent is a monopoly right granted to a person who invented a new product or process of making an article. So in common, you can say like a person, if gets patent, they will have for 20 years this monopoly. So under the Indian Patent Act of 1970, and after the off period means once the 20-year period gets over, then what happens is they have to go for the renewal of this particular patent. So there are certain procedures are there for the renewal after the off period or expiration of that particular period, you can say. So the inventor has to file first his work, and then based on that it becomes public. So in the public scenario or the public platform, they will be displayed. If anyone want to find it out, they have to search it and they have to check it, and then based on that, if it looks similar, they can also file a case. So this all details and searching and all, madam is going to take out, Bhuvneshwari ma'am. So we will see that in the next session now. So the patent, if it is applied in a particular country, it is only for that country. You cannot say that it's the international patent. Why? Because on that country, for example, India, if you want to apply for any patent, here the laws are different when compared to US. So based on the Indian pharmacopoeias or US pharmacopoeias and all, based on that only these will work. So we can take an example of the pharma company like there is a new drug which is developed in the Himalayan drugs for some salary. Some group of scientists are there who are working, and they are working for some salary, and they developed a new drug. So the patent, if they want to make it, the patent will be named in the name of Himalayan drugs or Himalaya drugs, and it is not the property of the scientist then. So what will happen? The scientist can claim for some processes or composition or some kind of method which they develop. For that, they can have the patent, but not on the product. So this is what, basically you can say this is like a product patent. So we will see the differences based on that. If you see the history, as I said, it all started during 1856. After that also it was there in the disguise. Many products from Britishers period, that is from London, it will be transported to India and then be sold here. So many companies from abroad, they settled here and they started manufacturing. Industrial revolution in India also started. So in the period of 1911, the Patent and Design Act was introduced by British government. Why they made this? Because many Indians were also making the same kind of material in India. So what happens? If Britishers want to survive in India, they thought that if they make this patent, the Indians cannot use it because they have to pay the royalty income to the Britishers then. So in those aspects, this 1911 was an important period for the Britishers where they started the Patent and Design Act. After the independence, till that time also, there was some differences and amendments which were happening, but it was in the favor of Britishers only. After 1947, 1970 is a very important period. Why? Because in 1970, the Patent Act became as Indian Patent Act. So the Indian Patent Act actually helped to give the, in terms of product patent, which was introduced in 1911 by the Britishers, Indian Patent Act introduced one more thing that is called as Process Act. So Process Act means if, for example, 20-year period is done, okay, completed. If a company has completed 20 years of their term, then what happens is they will have the process in which the product has been developed can be used by any of the company and they can manufacture in India. So the process can be used and the process can be patented. Like that, the rule came. So what helped? Why this rule came and how it helped India? If you see in India, since we were in the developing period, so this rule actually helped India to manufacture more kinds of food and drug materials in India and also to export it to the other countries. So because of this, India became the highest manufacturer of drugs and cosmetic, you can say like food items in India, that is in the world. And if some rules were also amended in 1972. But later on, for a period of almost, you can say 20 years, India was manufacturing and was exporting and was earning much. By 1990-95, when India joined WTO, World Trade Organization, they signed the trade-related intellectual property rights that is called as TRIPS. So when the India joined the TRIPS agreement says that it will be only the product patent, not the process patent. So what happened was, since India was a developing country, TRIPS agreement said the developed country can have 5 years term in which they can change this and they can modify or amend their rules and they can go for the product patent. The developing countries, they had 5 years term, extended for another 5 years, total of 10 years is being provided for the developing countries like India and other countries. And least developed countries like Africa and other places, they got a period of 11 years. So in this part, by 2005, the patent rules and regulations were amended and it became as Indian Patent Act. Amendment Act was made in 2005. So what were the things which were added in 2005? You will see in this. So what is patent? If you see the patent, it is a grant from the government which confers on the guarantee for a limited period of time the exclusive privilege of making, selling, and using the invention for which a patent has been granted. So, as I said, once the government provides you this patent, you are having the monopoly. So, what happens? The purpose of getting this patent is basically to enjoy the exclusion rights over the invention. Exclusion rights means you will get the money, royalty income, you can say, or you can keep that and play as an important player. As a you can start your own company also sometimes, and you can earn money. So the patent is to ensure commercial returns to the inventor for the time and the money spent in generating a new product. So what happens? What can be patented in this? You can patent based on your inventions. It must pass through the tests, and then you can go for the patenting. So the invention must fall into 5 statutory classes. You can say like processes, machines, manufacturers, composition of the matter, and new users. It can be like any of the above. It can be new users for the particular aspect. So it must be useful, it must be novel, and the invention must be non-obvious. So it should not have any kind of damage to any kind of environment or to the public. So it should be like that. So in that aspect, there are so many patenting cases are there. I will take one of the cases and I will explain you in that how this patent is going to be benefited and how this amendment of 2005 helped you. So the patent law, if you see the patent law, salient features of this patent law, so it is basically both the product and the process patent is being provided. So product patent is available all over the world. That is, in each country they have only the product patent. But in India, it is a unique thing. As I said, in 1970, India introduced this product and process patent. Because India is the first and pioneer country which started this product and process patent. So it is a period of 20 years. So in this 20 years, what happened was from 1970 till 1990, many companies, they used this process and developed new generic products in the market. So examination on request, anything can be done by the organization. If you give a petition, you can. Yes, ma'am.
Sir, excuse me, sir. Sir, are you changing the slides, sir? So are you changing
Yes,
the slides?
Yes, I'm moving it.
Sir, actually, the slides are not changing, sir. Actually, the first slide, it is still in the first slide.
Still in first slide.
Yeah, sir.
One minute, ma'am. 1 minute. 1 minute. I will just check it once. 1 minute. I will just share again. 1 minute. Ma'am, if anything is there, please let me know, because I will not be able to see that what is happening in Google. So please let me know. Okay.
Exactly. Sir, actually, we thought that you're giving a general note of patent and IPR. That's why I didn't interrupt you.
No. I already started it. 1 minute, ma'am.
Okay, sir.
1 minute, 1 minute. Is it visible now, ma'am? Can you see my slide?
Yes, sir. Yes, sir.
Is it moving now?
Sir, no, sir, no. Yeah, sir. Sir, can you please give the slideshow, sir?
1 minute, ma'am. I'm just doing that because there is some technical issues. 1 minute. Okay. Can you see my slide now, ma'am? Is it okay?
Yes, sir. Yes, sir. Yes,
If
sir.
any difficulty or challenges is happening, please let me know. Because I am not
Sure.
able to see the audience or the public. I am only able to see my slide now here. Okay.
Okay, sir. Yes. Thank you.
Okay. Okay, so as I said, there is a long history of patent. So from 1856 onwards, as I said, it has been started. And as I said, in 1970 is a very crucial period for India. So what happened was India introduced this product and process patent regulation amendment, which was happened, and it became as Indian Patent Act. And by 20 years period, from 1970 till 1990, India's drug development or pharmaceutical companies, everything started increasing because many British companies which were there or foreign countries which were foreign companies which were there in India before 1970, they finished their 20 years period in this term itself. So what happened? Everyone can use this process and they can manufacture as a generic product in the market. In the food sector also, the same thing happened and many exports happened from India to other countries and India started to flourish. So other rules, if you see, or laws which you can say is you can request for the examination, pre-grant and post-grant opposition. That is opposition. Why I'm saying this is if the grant has been, if someone files for a patent and if the other person says that this is my work and they wanted to file a case, they can do and they can fight for this particular patenting. And fast track mechanism for the disposal of the appeals is there. Then provision of the protection of biodiversity and traditional knowledges is also available. Like, for example, there is a very famous case from our India itself. That is after 1995 till 2005, what happened was the neem, you know about neem, turmeric, all these things were patented by foreign countries. So what happened? When they were being patented by the foreign land like US, so to fight against them, it is very difficult. So a group of people from India, that is mainly from Tamil Nadu, CSIR organization, IISc scientists and many other law experts, the panel actually went from India to US and they fought for it and they have shown the documents, 2000-year-old documents of India, and they got back many of the products back to India, like neem, turmeric, then basmati rice, so many things. So like this, to preserve the biodiversity and to protect the traditional knowledge, patent plays a very important role. So the publication of the applications after 18 months, the facility for the early publication, and substantially reduces the timelines because nowadays it is all online basis. So it is very easy to register yourself and go for the patenting. So in this aspect, how to safeguard it? The basic thing is the compulsory license to ensure the availability of the drugs at a reasonable place happens, that is the prices happens. Then for the public health emergency, see, for example, you wanted to manufacture a particular kind of medical devices, and in that aspect, or a medical supply has to be there, like the chloroquine was there during the period of Corona. So at that time, during the public health emergency, the patent can be applied very immediately for, like US was not accepting it previously, and then it made accepted. And then many places in the US was supplied with or imported with, exported with chloroquine and many things from India only. The same thing happened with the Covaxins also. The same thing happens with many of the vaccines from India to other places. During the medical emergency, these patents can be done very immediately. Then revocation of the patent in public interest. See, for example, a product is there and it is not suitable for the public. If the public makes a PIL in the public interest litigation, if they give, the particular patent can be closed and the particular product will be removed from the market. So also on the security considerations, like if any weapons or any kind of damaging things or warfare things is being made, then on that also, if the patent has been applied, then that can be revoked based on the public interest litigations, PILs. So what are the types of the patents? If you see, there are 3 types of the patents which have been granted. That is like ordinary patent, patent of addition, patent of convention. So as I said, the classification, you can have a second type, that is the product patent, or you can say process patent. So product patent is a very common thing. From very long time it is being available. Process patent, as I said, it is being started in 1970 and India is a pioneer, and now it is available in most of the countries along with some amendments and some kind of changes. So the patentable inventions, if you see, related to the process or patent or product or both, it can be done, but it has to be new or novel. It involves the innovative or inventive steps, then only it will be accepted. Then it should have a facility, that is clause is being provided that it should have industrial application. If you are just producing a product and it is of no use to the society or no use to the industrial level, then the patent is just a piece of paper then. And there are certain things which doesn't fall under the section 3 and 4. Like new, the terms are there, like new means the invention must not be published anywhere or elsewhere in the publications or anything. And the prior public knowledge or prior public use within the India should not be there, and claimed before in any specification in India. So, see, for example, a product which is being made in Haryana cannot be patented in Tamil Nadu saying that this is our product. So based on that, clarity should be there. Now, since it has become digital, so everyone can check in the website saying that which are the materials which are being published, in what name it has been published, what are the articles which are being published. They can search easily. So ma'am will discuss in detail right now. Okay, so the inventive steps means what are the technical details are there? What are the, we can say like very minute things also you have to present there, and you have to give a justification for that particular thing. So it involves the technical advances as compared to the existing knowledge. And industrial application, as I said, it can be, or you can say it can be, or it should be like that. You can make being made or used in any kind of industries which are related to the particular subject or field. There are certain sections are there in which the exclusion are being included. So the exclusions are there, like section A, section B. I'm not going in detail with this. Basically, the section A, you can understand that based on the nature of laws of the particular country, like the machine that gives more than 100% performance or perpetual machines, then the commercial exploitation, like B says about mainly the commercial exploitation or the primary use of the inventions, which is contrary to the public order or morality, like you can say like a gambling machine or a machine which is a device for housebreaking or something which is burglary, or you can say theft or something like that. Those items cannot be included in the section as per the section B. It also includes many other things, like if any damage happens to the public or the environment, so that cannot be involved, like prejudice under the serious prejudice under the health, human, animal, plant life, or to the environment, so it cannot be included. Then biological warfares, then weapons of mass destructions, terminator gene technology, or embryonic stem cell. You know that embryonic stem cell, when we are doing, there are certain clauses are being made as per the LNC Act. So based on that, if you see the embryonic stem cell, there are certain rules and regulations are being given as per the ICMR guidelines and the Institutional Stem Cell Committee guidelines. So based on that only they can work, but they cannot work directly on the embryonic stem cell, creating a new thing like the tolling. I will just take this particular section, section 3D, very seriously. Why? Because, as I said, in 2005, when the amendments were made after the TRIPS agreement, India was facing a challenge. Why? Because as per the TRIPS agreement, they provided 10-year time. So 1995 till 2005, they were having the time. So in 2005, what the Indian government did was they made an amendment in the patent law, and as per this patent law, why they made this was, I will give you an example. Now there is a particular company who manufactures a particular product, okay, a particular drug. They are having this patent for 20 years. Now after this 20 years, the previous method what they were following was they will make a slight change. So for making this slight change, they will appoint a group of scientists, and these scientists, what they say is, okay, at the position 6, we will add one more ring structure or something like that, or they can add one more property in that, and just to give it in the market, saying that, or some combination they will make and give it in the market. And they were getting a patent, and again 20 years they were enjoying. India saw that particular thing, and India thought that it will not work because the prices were increasing because of this amendment, because of this changes, the prices were increased in the normal drug itself. So the drug control body which is there in the India, that is the DCGI, along with the Patent Authority of India, they made a decision that the drug prices should be controlled. The prices of the essential drugs should not come under this particular contract or any kind of law, because essential items like if you are having a paracetamol, and if the paracetamol is being added with some other thing and being provided, the cost wise it will increase. Instead of 10 rupees, it will go to 100 rupees. So it is not affordable for the particular Indian. This 3D in the IPR. The aim of this was, as I said, the MNC were always planning for a maximum profit. So after 20 years, what happens, as I said, when they will appoint a research team and they will make this small changes and they will patent. But the conclusion, what happens to it is, they said that patent, as per the amendment, they said that there should be effective or enhanced efficiency should be there in the product. So what is this enhanced efficiency? So what happens if there is no enhanced efficiency, you cannot enjoy the monopoly. So before that, what were happening? They were having the maximum profit. After 20 years, they will set up a research team. After setting up the research team, they will modify this product lightly or slightly, and then they will apply for a new patent, and for 20 years again they will have a monopoly. This is called as evergreening of patent. Due to this, Indian government wanted to stop this. So they said that it should have enhanced efficiency when you are applying for a new patent. So there was no clear definition for this enhanced efficiency, and the best example what we can take is a Novartis case. Excuse me. So in the Novartis, you know that Novartis is the biggest pharmaceutical company which manufactures most of the drugs related to diabetes, related to cancer, related to hypertension in the market, along with some nutraceutical things also, like Sandor. You know that Sandor is for calcium supplementation. So this is also a part of Novartis only. Novartis manufactured a drug. This is called as Glebac. Okay. So this is basically they wanted to have this drug at a very high price for cancer treatment and other treatments. But the patent office, what they did was they rejected this particular drug, and they said that there is no enhanced efficiency in this particular product. So they approached the Supreme Court of India, and when they approached the Supreme Court of India, they gave a clear definition for this enhanced efficiency. They said that enhanced efficiency means therapeutic efficiency. So therapeutic efficiency means what? That is, it should not have minor improvements. It should be enhancing the therapeutic aspect and not simply enhancing the particular product. So they rejected it, and that is why the Glebac is having no patent in India. And also after this, many foreign companies which were there in Indian soil, they were facing this particular challenge, and they were having a issue. So what happened because of this? Because these companies are, maximum companies are from US, like Pfizer, or you can say Novartis, or some different companies are like AstraZeneca and other things are there. But if you see, because of this, the consequences, what happened was US became agitated, and US made under the priority watch list. So priority watch list means means if you want to export anything to US, they will always check it, and they sometimes reject also. So like that, it can happen. So in that list, they were keeping us, and because of this, the US business were actually coming down. The establishment of many research-based companies in India started moving out of India. And after this, many other countries have adopted this Section 3D in their IPR. Like Brazil is one of the countries which adopted it. And this created another challenge for US because they cannot invest on these countries for manufacturing and to make the new products there. So what is the advantages? Basically, thing is it gives affordable, the drugs becomes affordable, capable of producing for other countries, increased exports, set as a model for other countries, India has become. So, but the disadvantages by this is US patent, the US Patent Office and US has made us under the priority watch list. So during the 17, 18 and 19, you know that many patents became off patents. So what happened after that was most of the research units which were set up in India during that is from 2011 to 2019, most of the research companies were closed. Biotech companies or pharma companies were, research divisions were closed. Only the manufacturing divisions were kept in India. So that is the disadvantage which happened in India right now, because there is very less amount of research institutes related to the particular pharma companies in India is very less. Only few are having this particular scenario because of this particular section. So as you know, the Novartis company, after this particular case, they closed their research division in India and just they kept only the quality assurance and quality check in India. The rest of the research which is there, it is happening in China and Vietnam and Korea. So they are having their manufacturing as well as the research centers maximum in other places except in India. So there are certain non-patentable inventions are also available as per the Section 21 of the Atomic Energy Act 1962, which are not patentable. Like you can say, like if a soil is there and it is having a rich amount of thorium, you cannot patent that whole land or soil saying that our land is filled with thorium, because as per the Act, the Atomic Energy Act, that is a property of India and that cannot be patented. So the inventions related to the compounds of uranium, beryllium, thorium, plutonium, radium, graphite, lithium, and many more. As per the central government, from time to time, they give the list in the website, and based on that, it will be added up. So as I said, the terms of the patent differs, but the common thing is 20 years. So in respect of an invention, claiming process of manufacture of a substance intended to be used as food or medicines, you can say 5 years from the date of sealing or 7 years from the date of patent, whichever is shorter for food items, mainly for food items. Medicines, it is there for 14 years normally, and after that it is being extended to almost another 7 years. So total you can say like 20 years. That is why we say for medicines or pharmaceutical materials, it is nearly like 14 years. In other cases, if anyone want to patent any kind of composition or something like some kind of music or something like that, it is going to be almost like 14 years only from the date of patent. So expiry of the patent, if you see, once the full term is being over, because like 20 years is done, then it becomes as off patent, and then the person has to go for the renewal. If the renewal fees is not being paid on time, then also the patent will expire. The another thing is the validity of the patent has been successfully challenged. That means, say for example, a patent is running and they say that this patent is causing any kind of damage to the public because of this product. They can challenge the court and the patent can be revoked and it can get expired. Or if any opposition is there, pre-post, there is a pre-patent or post-patent, if any opposition is there, they can go to the court or the patent office and they can stop the particular process then. And as soon as the patent expires, it passes the general public domain. Okay, it passes in the general domain list, and anybody can use it without the permission of the original inventor. That is why we said that after 20 years, the process patent, as per the amendment part comes, the section 3D comes into play, and it helps in many aspects. Am I audible?
Yes, sir, you're audible.
1 minute, some technical issues. Sorry for the technical issues because of this internet. My system is getting hanged up. So if any challenges, please, sorry for that. Yes. Yes. Can you see my slide? Is it moving?
Yes, sir.
Okay, fine. Thank you. So there are almost different steps are involved for the filing of or granting of patent. So for obtaining the patent, the basic thing is you have to register yourself. The application has to be, you can take the application, manuals are available for free of cost in this particular website, that is www.ipindia.gov.in. There you can see the different categories of IPR, that is patent, trademark, then copyrights, so many things you can see here. And based on that, if you require any kind of patent or trademark or design or anything, you can go to that particular website, particular site, particular domain, and there you can see the manual which is available for that. You can read the manual, it is free of cost, you can download it, you can read the manual. After that, you can segregate all the documents which is related for submitting this patent and the application form also. Fill up the application form. Before that, you have to log in, you have to create your password, and then you can go. So we will see this website in the end. I'm not going detail right now. So in the end, we will see this website in just a brief. So the formality checks, so they will take some time to check all the requirements, what before accepting the fees as well as for the application. Once it is done, immediately they will issue the number and the cash receipt. So that you can download it on the same day itself, and then in case of the receipt application is coming by post, the cash receipt and other things, it will take little time. But nowadays they are not doing by post. This is an old thing which I'm keeping here, but the new format as per the 2019 onwards. Okay, so 2019 onwards, they have made compulsory to file the patent online only. You cannot give by manual mode now. So the publications is kept secret for a period of 18 months from the date of filing. The 19th month, the application is published in the official journal, and this journal is made available on the website on the weekly basis. And applicant, after this, what they can do is also they can have this option of taking this before the 19th month. If someone claims, someone claims about this particular thing on the 19th month, if it comes in the official journal and they want to claim, then also they can claim or oppose the particular patent, and they can file a case after that also. So application is published within 1 month of the request then, and the requisition of the examination process, if you see, once you submit the application is examined on the request. Then the request for the examination can be made either by the applicant or by the third party, and a period of 48 months, it will take nearly 2 years, it will take from the date of filing is available for making the request of examination. So first thing is within the month, that is application, when you send it and to an examiner within 1 month from the date of the request of the examination, the examination takes, the examiner will undertake this examination, like whether the claimed invention is not prohibited for the grant of the patent or not, or whether it is being published anywhere or not. They will check everything. Then they check that whether the criteria, whatever is being provided in the document, it is being fulfilled or not. So you have to make a systematic document where the checklist has to be kept on the first page, and then you have to submit. So there are certain things which you have to mention here right now. Then the issue of the FER, so the first examination report, if you see, so the period of 1 to 3 months is available to the examiner to submit the report of the controller, and 1 month time is available to the controller to vet the examiner's report, and containing this list of objections is issued within the 6 months from the date of the request. Then what they can do is they can go for the case or filing the public issue litigations. So the response from the applicant, they will wait for 12 months time from the date of the issue of the FER is available to the applicant to meet the objections. So 12 months period is there, nearly 1 year period is there with the applicant and also the other persons to check and to object. So if the objections are met, the grant patent is being approved by the controller within a period of 1 month. So pre-grant opposition. So if you see that pre-grant opposition before the publication, or you can say after the publication, an opposition can be filed within a period of 6 months. So after you have submitted, after the controller has accepted, the publication has happened, then also you can oppose and you can file a case. So the opportunity of hearing the opponent is also available either in the patent office or they can go to the High Court or in the Supreme Court directly. So the examination of pre-grant opposition, so they will do the document check, opposition documents, what the other person has sent, that also they will check, and they will take 3 months period is allowed for the receipt of the response. And within this 3 months, every week they will update sometime. Sometimes after 2 weeks, they will give you a mail saying that this is being done and so much have been done and this is being checked. Like that, the mails used to come and they can check it regular basis. So the consideration of the pre-grant opposition. So after that, examining the opposition and the submission made during the hearing, controller may either reject the opposition and grant the patent or accept the opposition and modify or reject the patent application. If this happens, if they consider and they say that you have to modify and they modify it and they submit, then within a period of time, the completion of the opposition proceedings happens and the settlement happens, and after that, the grant of the patent happens. Within, you can say within 7 days, you can have a certificate of patent, and then in the official journal, it will come into play. So these are the different stages where it is happening. You can see the stages which are filing of the patent. First is the filing of application, that is a provisional or you can say complete application has to be submitted. Then publication of the application promptly after 18 months. For 18 months, they will keep this application, process it completely. After that, they will publish it in their journal. Then the request of the examination, it is almost within 48 months from the first day, you can say it will be considered. Then examination, issue of the FER, that is the third party representation will be taken up. Then all the objections which are there compiled within the 12 months will be taken up, they will be heard and they will be understood in this particular aspect. Then the grant of the patent will be happening. If anyone want to make an opposition, they can make an opposition at this particular stage also. So within 12 months of this particular period, the opposition can be done and then the decision of the controller happens. At that time, they can go for an appeal and appellated board is there. So where if you want to revoke or you want to have an amendment in that particular patent, you want to add anything extra, your points or anything like that, you can do at this particular moment and then it will be published for the public. So renewal, as I said, to be paid, there is in the terms that are being provided. So to be paid within 3 to almost 3 plus 6 months, almost you can say 3 to 6 months from the date of the recording in the register. So the section 142 of the clause 4. And first and second year, as I said, nearly 18 months after that only the processing is happening. So for first 2 years, there will be no fees, but the renewal fees on the yearly basis has to be paid. That is from 3rd year to the 20th year, you have to pay the fee regularly every year. So if you are not you are failing to pay this particular fees, what will happen? Anyone, they will just close this or it will become as expired. So in this case, anyone can claim the particular thing and they can apply for the patent. So delay up to 6 months from the due date permissible on the payment of the fee for the extension time is also available. So the patent lapses if the renewal fee is not paid within the prescribed period of time. So rights of the patentee. So what the rights are there for the patentee? You see the right to exploit the patent. That is, the patentee has the right to prevent third parties from exploiting the patented invention. So if any third party is there or any other person is there, they want to use your patent, they have to take your permission. If they have not taken the permission, you can file a case against them, and at that moment they will be either sued in the court with fine, or they will be arrested also. A grant right to grant license, that is a patentee if, is being approached by any company and they want to give the patent on the royalty basis to get the money, they can grant this license to anyone, has a power to assign the rights or grant the license also. And second thing is the right to surrender. So if, for example, I don't want this patent, I want to make this patent public. The best example is from Coimbator's Arunachalam Muruganandam. You know that Arunachalam Muruganandam was is a person who made the affordable sanitary pads. Okay, so affordable sanitary pads he made by a machine. So based on that, only the movie came called as Padman. So this, in that case, instead of making a patent, he made it public. So he will just give it on a public basis to anyone. So in that case, the patent is given the right, patentee is being given the right to surrender the patent by giving notice in prescribed manner to the controller. And right to steals your work or copies your work, you can go to the district court or the high court or the Supreme Court and appeal for the PILs, and against that particular person you can go for a suit or the case, and the person can go to the that is either to the jail, or they have to pay the fine or the royalty to the particular patentee. So thank you. I hope that you must have got some idea about the patent and the Indian Patent Act in India. So before closing, I just wanted to go to the particular website. I will just show you just a basic thing. I'm not going to show the complete steps here regarding the patent part. So just a minute. 1 minute. So in this meantime, if anyone is having any doubts or anything, they can just post it or they can ask. Am I audible? Is it okay?
Yes, sir.
Okay, 1 minute. I'm just sharing my screen here. 1 minute. Yes. Can you see my some technical issues? I'm sorry for this technical challenges which is happening from my side. So I'm just taking you to this particular site. This is www.ipindia.gov.in. Can you see my slide?
Yes,
screen?
sir. Yes, sir.
Okay. So when you just type in Google this particular site, you can know about various things, like it will talk about various things, like as I said, patents, designs, trademarks, geographical indications. Then there are so many other informations which are available, like workshops and other things which are available. So in each, you will see that there are details which are available. So going on with the patent part, I will just take you to the publications. So in the publication, there is a manual is available. So I request, if anyone want to go for the patenting part, they can go to this manual. When they click this manual, they can see that it is in the download formal, that is the procedure wise, that is what are the documents are required, what is the practice which is being followed. They can read the complete documents, and then patent office procedures, what are the different patent office procedures are there. Then first stakeholders meeting, which is when it is held, everything will be mentioned here. So if anyone want to publish or want to get their patent, please, the first two documents are very much important to read. After reading this particular thing, what you can have to do is you can just go for the 1 minute. There is a patent examination is also available if you want to become the patent agent, because there are certain companies are there when you finish this particular course. Okay, there are certain educational societies are available which are providing the training for this patent agent examination. If you read from them, they will provide you the study materials and other things which are available in Chennai itself. There are certain institutes are available. So you can get the materials, you can read, and you can apply for this patent agent examination. When you clear this patent agent examination, students from biotechnology, biochemistry, or from any other field which are available in life sciences, if they do this particular course, what is the advantages? They can go into the MNC companies or manufacturing companies or drug-related companies like Biocon or Novartis, and they can practice as a patent agent there. So what will be the advantage there? Because in any of the agencies, if you practice, you can earn from around 50K as the starting in this particular aspect. 40K to 50K is the starting salaries which is being paid for patent agents in topmost pharmaceutical companies as a junior level. I'm saying about junior level itself, you can start after finishing your PG. If you are doing along with your PG this particular course, you can get into the job very easily. So another thing which you are having, this is, as I said, drug patents are there. So you can check for the drug patents, other publications. So many things are available. So lack of time, I'm not going in deep with this. Please check all this site and the websites so that you can have more details related to the patent and the Indian Patent Act. Thank you. Have a great day. And I hope that you have enjoyed the session. If you have any doubts or anything, please let me know.
Thank you, sir. Your valuable inputs have given us the knowledge about patent law, safeguards, and histories about protection of biodiversity. Thank you for giving us a deep insight on the acts of IPR in explaining about the various sectors. You have given us a clear note on keeping biotechnology thick, which can also be a valuable form of protection. Thank you for making us to know the clear fact on how to process for the patent. Participants can post your questions in the chat box.
I see one question from Mr. Harsha. He's asking, is it possible to get a patent even if someone has been selling the product for a while? See, a product already, if you are having, see, for example, you want to start a company and you want to sell a product. So what you can do is, already in the market, if the same brand is available, I can give you a brand like Britannia and Sunfeast. You can take these two products. Okay. When Britannia was there or Parle-G was there, the biscuits which were coming, it is having a slight change. Okay. But when Sunfeast came, they brought a design. Okay. They brought a particular type of patent based on the design aspect, trademark. Okay. Trademark is one of the things which you can apply. The second thing what you can have is a taste wise or the process wise. So based on that, if you are having a change or benefit in that, see, if you are adding vitamin D in that, or if you are adding a fruitful thing in that, so what happens? This becomes as a new product that you can patent. Okay, this process and the product you can patent, but you cannot patent the same product in the market which is running from a long time. Same name you cannot keep. So the trademark is also available, design is also available, and patent is also available in this particular concept. I think Ilavarsi is asking about how to prepare. Yes, how can we prepare for that exam related to the patent, sir? Ilavarsi, I can just suggest you, 1 minute, I will just suggest you regarding the patent. And this is common for all also. This is being done from Delhi. Okay, Delhi, there are certain agencies are there which are running online exam for this. Every year this happens. This particular exam happens nearly in the month of October, November, and December. In this period only, this particular exam happens. And the coaching, everything is being by online mode. They will provide you what you call materials and other things. So I will just give you the detail. It is called as Institute of Patent Attorneys India, IPAI. You can check in their website. I will type it in the chat box, 1 minute, so that anyone can check this. So www.ipai ai.co.in. Okay, so you can check this particular website if anyone is interested for this after their MSc program or during their MSc final year. I propose that who are all there in the MSc final year course right now and want to become as a patent agent, please check this particular website. They are actually providing the training as well as slots for patent examination. Okay, so this is a very famous company from past 15 years, 15-20 years. They are actually helping India for getting this patent agent job actually. And once you clear this exam, there are so many things are there, like you can say that you can go to US also once you clear this exam, but you have to learn the US patent laws and all. After clearing the US patent laws examination, you can practice in US also, in Canada also, and other places. But only thing is, country to country, the law changes. So every country you have to read the you have to read this patent laws, and then only you can go there. And Harsha is asking, how much does it cost to patent an invention? Roughly, you can say the patent application wise to the patent, it will come around like near to 2 to 2.5 to 3 almost, you can say. Yes, any other questions?
Sir?
See, when you are applying for a patent, Harsha, I think one more question came. So, is it possible to obtain a patent and keep the invention confidential? Yes, you cannot say like that, because once the patent is being applied, it will be posted in the group, that is in the official journal, it will be published. So anyone can search for it, and only thing is the process wise, you can keep it secret, but you cannot say that the product is, you cannot use it or something like that. But if you are going to go for any rewards or royalty for any company, for them, you can grant this license, they can manufacture it and they can give you a reward. I hope that yes, Dr. Prem Kumar, actually, yes, you can apply, but thing is, right now in India, we have to check the rules again. Again, I'm saying we have to check the rules again, because the process patent, previously the process patent was available in which this methods and protocols can be applied. But now what they have made is stringent, little bit stringent from 2019. So if you are applying for any method, okay, that method has to be validated, because you have to have so many rules and regulations. Because since I worked in stem cell research previously, so what happened was, when we were approaching for the method, because we developed a new method for the stem cell research, stem cell isolation and all. So when we approached for the patent, there were many challenges which were happening, because they were asking for institutional ethics committee permission. They are asking for the stem cell committee permission, which is being given by the ICMR. They are asking for the DCGI approval for the GMP facility. So many rules and regulations have been present there. Then only that process can be applied. Like that, the rules have become a little bit stringent. So we have to check it, and I also have to check it, frankly to say. Okay. So, any other doubts, please?
Sir?
Yes, ma'am.
Sir, in case of collaboration work, if you want to give a patent for protocols or either the product, how maximum of how many people can apply for the same, sir, in case of collaboration work?
Ma'am, in case of collaboration, see, for example, you are collaborating with any company. If you are applying for any company and company approaches you and they accept your patent, saying that, okay, we will take up your patent, you can grant us the license. So in that case, since you are working in an institution, so the institution will be having some partnership. So individual partnership you cannot have at that moment. You have to go through the institutional parameters, because the institution comes into the play there. You will be the primary investigator, or you can say the primary patentee there, but the secondary patentee will be the institution patentee. So the institution will be the secondary one, and then you can approach to the particular organization. So I can give you one more example, because when I was doing my MSc project, so we got a new project, a novel project by which the biosurfactant is very good, and the amount actually was working. So we approached for the patent, but the thing was, it doesn't came on my name. It came under the institutional name, because it is a property of the institution, because I used their chemicals, I used their chemicals, instruments, worked everything. But only thing is, the process part I can claim on my name. Only the process part I can claim, not on the product. So that product will be a property of the institution only then. If you have already got a patent, see for example, you have during your PhD, you have worked and you have got a product and you have patented it, and now you are there in one of the institution where you are working, then what you can do is, in that case also, you can have a collaboration MOU like thing, in which you can give the terms and conditions and then go for the patenting part. That is only I can suggest, but there are certain rules and regulations. You have to check it in the procedures of the IP, as I said, the official website. You have to check, because rules are changing day by day. Every day the rules are changing, so we have to check it in the website.
Thank you so much, sir, for your clear note. Thank you, sir.
Thank you, ma'am. Thank you for Digi Vaishnava College and management for inviting me here. Thank you for all. Thank you.
Thank you, sir. Now I would like to call upon Dr. A. Shivaranjani ma'am to introduce the speaker.
Good morning, all present here. In the knowledge society of 21st century, intellectual property rights or real assets are much more valuable and important than materialistic assets. Significantly, biotechnological invention involves monopoly over life or living beings or living processes, and morally and ethically, these are considered to involve tinkering with life or nature. Patents are viewed as vital to protecting the commercial interests and intellectual property rights in biotechnology. Patents are limited rights based on a claim that a new technological invention has been created and fully communicated to the public. So, listening to our speaker on today's webinar will find cutting-edge knowledge on the importance of patents, which will fulfill few important conditions such as novelty, inventiveness, industrial application, and written description. I have great pleasure to introduce Dr. V. Bhuvaneshwari, Assistant Professor, Senior Grade in Biotechnology, Sri Shakti Institute of Engineering and Technology, Coimbatore. She's having 11.5 years of teaching experience and 17 years of research experience. She worked as Associate Professor and Head in Department of Biotechnology, Kongunadu College of Arts and Science, Coimbatore, from 2013 to 2020. She worked as lecturer in School of Biotechnology, Dr. G.R. Damodaran College of Science, Coimbatore, from 2007 to 2008. She worked as lecturer in PG Department of Biotechnology in Sri Nehru Mahavidyalaya College of Arts and Science and Kumaraguru College of Technology from the year 2007 to 2009. Her academic credentials include Doctorate in Biotechnology in Amity University, Noida, MPhil Biotechnology in Bharatdasan University, Trichy, MSc Biotechnology, MSc Botany, and PG Diploma in Bioinformatics in Bharatiyar University, Coimbatore. She got very good academic record with university ranks. She was a gold medalist in both UG and PGs. She got very good, and she has completed UGC minor research project grant for 3,20,000 for the period of 2014 to 2016. She got qualified SLED in the year 2006. Currently, she's having BSc major research project for rupees 18.3 lakhs that was sanctioned during the year 2019, and this takes the period of 2022. She had filed 3 final Indian patents and one of her innovation on a method for DNA protein interaction in plants that was granted on 2019, and her patent number was 325819. She has research publication of 61 in reputed international journals with cumulative SCI and SCIA impact factor of 50. She has organized and acted as resource person for hands-on training on real-time PCR, gene expression analysis, HPLC analysis, etc. She had organized 24 state and international and national level seminars, conferences, symposium, and workshops. She has acted as a resource person for 17 state, national, international level seminars, conference, symposium, and workshops. She had attended more than 50 workshops, training, and conferences. And she had presented more than 100 research articles in national level and international level, seminars, conferences, symposium, and workshops. She had guided more than 150 UG and PG projects and supervised 3 MPhil scholars and 6 PhD scholars. She is currently guiding 3 PhD scholars. She had published 4 books with ISBN number and 27 articles in the book. She had submitted 6 gene sequences in GenBank. She has acted as an institutional member in Animal Ethical Committee, CPC SEA, New Delhi, life member in Indian Science Congress Association, and she is elected as committee member for Indian Science Congress Association, a new biology session for the period of 2020 to 2022. And she was annual member in Tamil Nadu Science Forum, coordinator for MHRD's Institutional Innovation Council, and awarded as ambassador for it. And she is serving as the guest editor in the journal Energy Nexus Elsevier. And she is serving as the editorial member for the following reputed journals. Those are Journal of Microbiology and Biotechnology Reports, SF Journal of Biotechnology and Biomedical Engineering, Microbiology Current Research, and Stem Cell Research and Therapeutics. She was associate editorial member in Bentham Journal titled Current Nanotoxicity and Potential. I feel very much honored to introduce such an eminent speaker, Dr. Bhuvaneshwari, and it's a privilege to be the audience to his valuable inputs. It is very much correct if I say that the Institute is fortunate enough to have her valuable time with us, and also look for much more future engagements with her. With these few words, I would like to hand over the session to our eminent speaker. Please, ma'am.
So, good morning to one and all present here. I first of all thank you for inviting me for the workshops. Thank you, Dr. Sivaranjini, for nice introduction, and I should thank the Vaishava College also and head of the department also for inviting me. So I am having some technical network issues. I can't able to share the slides. Dr. Sivaranjini, ma'am?
Ma'am, can I, ma'am? Please share this. Okay, ma'am. Will you please share your...
No, can you please give the permission or stop sharing your slide?
I have stopped sharing this.
Okay. So,
will you please try
telling that grant permission like that.
Oh, wait a minute.
So you must grant permission like that, it is telling.
Excuse me, ma'am. We'll check it. Ma'am, it is granted only, ma'am, actually.
Shared or not?
Ma'am, it is an accessible option, ma'am. Can you please try it once, ma'am?
But it's telling. So shall I send it to you? Sivaranjini, shall I send it to you?
Yeah, ma'am. Yeah, ma'am. You can send it to my mail, ma'am. I'll share.
I'm sending through your WhatsApp.
Yeah, ma'am. Yeah, ma'am.
Through your WhatsApp, I'm sending.
Yes,
so
ma'am. You can send it either to WhatsApp or mail, ma'am. No issue, ma'am. You can send it by either mode.
Okay. Correct. Shivranjani, I have sent it through your WhatsApp.
Okay, ma'am. Okay, ma'am. Thank you, ma'am. Ma'am, I didn't receive, ma'am.
Yeah, it's coming.
Welcome, Dr. Ansavini, ma'am. Ma'am, can you hear me? Dear students and participants, please hold on for a minute till we settle with the technical glitches. Thank you.
Good morning to another present here. So is my slide visible?
Yes, ma'am.
Okay, thank you. So today we are going to see about biotechnological inventions and patent law in this workshop. So as we know, the intellectual property rights is the rights for the person for their creation of their minds. For knowledge, we are protecting the rights. As we have property like house, cars, movable and immovable property. This is the property. Is the slide moving, Shivranjani?
No, ma'am. Ma'am, will you please select the slideshow mode?
Slideshow only I have selected it.
It's not moving, ma'am, actually. Okay, ask her to click the slides. Ma'am, can click the slides, ma'am. Yeah.
So
Change.
I think slideshow is not working. Oh, I will show the like this itself.
Okay.
Is it okay?
Is it okay? It's okay, ma'am. It's okay, ma'am. You can go with that.
So this is the first slide. So now the slide is showing intellectual property rights.
Yeah, right, ma'am.
Okay.
Will you please be in video mode, ma'am?
So this is the intellectual property rights is the exclusive rights which is given to the creator for his creation of mind, so that it can be protected from others misusing without his knowledge. Okay, other industry or other persons cannot use without his providing royalty or without getting permission from the creator. So in the present scenario, the native microorganisms cannot be patentable. So whatever available in nature cannot be patentable, but genetically engineered ones can be patentable. But it should have some industrial importance. So it should have some industrial importance means if something genetically modified microorganism is, it can be patented. The slide has moved. Third slide. Ma'am?
No, ma'am. Actually, you have to click the third slide, ma'am.
Third slide.
You didn't click the third slide, I think so. Yeah, ma'am. It's visible now.
Okay. So, as per the intellectual property rights, Dr. Srinath sir has already discussed, we have several categories like patent, industrial designs, trademarks, trade secrets, plant varieties, integrated circuits, and geographic indicators. Patent means if we can patent the products, process, and altered microorganisms, etc. Industrial designs means like if we are designing some instruments, so that model of the design can be patented. Some cycle we are designing, some electric vehicle we are designing, some bottle itself we are designing in a different manner, which should have industrial application. That design can be protected under industrial designs. And trademarks means for Apple, they have this trademark, so which is unique. No one should use their trademark. For example, Jio also they have trademarks. Like that, each and every company has their own trademarks, which others should not use. So by showing the trademark, we come to know that is the product of that company. So others should not use the trademarks. So apart from patents, there are trade secrets also. Trade secrets means, for example, Pepsi, they are maintaining as trade secrets, not patenting. So only 2 persons in the world know the composition and of that Pepsi. So they are maintaining as trade secrets so that others cannot copy it and use it. So for if trade secrets means we can use it for many years, but patent means the rights are provided only for 20 years. After that, it should be freely available for the public. So in order to protect our own products, many companies maintain as trade secrets also. So they will maintain the secrets, the composition. They will not tell to the employers. Only they will give without the name they will give, and the mixing only they will. The employers will do the mixing alone. And apart from these patent rights, there are rights for plant varieties. We can protect the particular varieties. Farmers can protect the particular hybrid varieties also. So that comes under plant varieties protection. And integrated circuits also can be not patentable, but they can be able to patentable if it is combined with the hardware.
So alone IC will not be alone patentable. If it is combined with the hardware, it will be patentable. And geographical indications such as like காஞ்சிபுரம் பட்டு, அப்புறம் வந்து டார்ஜிலிங் டீ, தஞ்சாவூர் பொம்மை, these are all geographical indicators. So the geographical and the Tanjavur and the Kanchipuram and all, they have particular quality of that product which other area doesn't have, and it is not we can't have individual rights. It is the group of people on that particular geographical location has to file for geographical indicators. So apart from this, there is copyright also. So literary works, books, poems, plays, films, music, artistics, drawings, photographs. If you have unique photographs, we can able to copyright it. And performing arts also, some unique arts if we are performing the model of arts, and even the presentation of PPT and presentation of the presenter can also be in YouTube, also can be copyright. And like this, you might be knowing the Ilayaraja sir was asking royalty. He has restricted SPB for singing the song under his music. Like that, the copyright will have restriction. We can make restrictions to others by copying. As for us now, we should not, if a book was there means we have to get copyright from the editors or the publishers or from the writers. Then only we can able to reprint the books. Like that, if cinema was there means they should get permission for that story or the screenplay. Then only in other language it will be replicated. So like that, these copyright protections and all there. So this whole thing contributes for intellectual property rights. So today we are going to concentrate on patent alone and how to, and what is a patent. Let us see what is a patent. Can anyone tell what is a patent? Is the slide move?
The slide is moving. The slide is moving.
So what is a patent? It is the sanctioned monopoly rights for a set number of years. Mostly it is 20 years. And slight variations will be there overall world. And it is sanctioned monopoly rights given for particular years for disclosing to the public. So as we are gaining protection, we should disclose our invention to the public. So after 20 years, it should be free for the public use. So, so by this patent protection, what creator will have rights means if anyone use the patented products or a patented process or any other idea which is patented, we can infringe our rights, okay, so that we can get royalty or compensation for using without our permission. So like that, this is a protection given for particular number of years only. So what is the patent law? Means first we have to disclose it. What our invention, we have to, if you don't want to disclose means we can maintain as trade secrets. First we have to disclose our invention and it will be published in the publication of patent office, and it should be non-obviousness. Non-obviousness means what? For a skilled person in the similar field should not think it is like for example, A plus B is equal to 2 means 2A plus 2B will be 4 only, no. So although it is different, A plus B is equal to 2 is different from 2A plus 2B, which is 4, but it is not unique. It is obvious to the skilled person. So whatever we are findings, it should be unique novelty. Novelty means new, and it should not be obvious to the skilled person, and it should have industrial application. That is more important. Without use, if you are finding anything means it cannot be patentable. So what are all things can be patentable? And if the term is from the filing date, it will give protection for 20 years. So it should have abstract and drawings and all, and whatever we have patenting, we should have given the proper justification. So this is the patent criteria. So criteria for patentable is it should be novel and it should not be available to the public previously. That means for same innovation, you might have published a journal, but that published article you should not patent it. First, if you want to protect your rights means first you should patent and then publish. If you publish first and then you can't patent, because anything available in the public cannot be patentable. It should not be known previously. Even in the forum or in the YouTube or in the Google search or in the anybody who has filed, it should not be available in the public previously. That is more important. So if you are doing some innovative work means don't disclose to anyone or don't disclose it in any public forum or don't publish before patenting. So it should have inventive step. That is, it should not be obvious to the skilled person. So a skilled person in the same area can tell that this is very easy, even I can do like that. This is not novel. This is not inventive. It is the normal process. No one should tell like that. So another criteria is it should have industrial application. So without any application, we can't able to patent anything, process, product, or whatever it is. Even genetically modified organism also, it cannot be patented until otherwise it has some use. Even genetic sequence also can be patented if it has some use, if we do some alterations. Not naturally occurring gene sequences cannot be patentable. And it should be described properly with clarity of claims. Claims is more important. So other things and all, normally everyone is clear, but putting the claims, whether the claims will be rejected or not, that is more important, because by providing the claims, we are protecting our future innovators from using our innovation. And if we give some normal claiming means it may be rejected also, because it is known to other skilled person. So providing the claims is more important. And who can file a patent application? A true and first innovator can file a patent. On behalf of the institution also, inventor, institution also can file a patent. His or her legal assignee also can file a patent. And if the inventor has died means the legal representative of deceased inventor, like that, if a person died means his nominee can file a patent, or his legal heirs also can file a patent. So is it slide moved?
Yes, ma'am, the patents law and practice.
Okay. So filing a patent, who all can file means the inventor can file, assignee of the inventor can file, the institution on behalf of the inventor can file, and legal heirs of the inventor can file. If the inventor deceased means, that means the death means his legal heirs also can file a patent. And how many years the protection was there means 20 years protection. In spite of that, we are allowing to disclose our invention. So the patent office will grant a patent after analyzing and examining. So as on date, the India is fully in compliance with its international obligations under TRIPS agreement. So the Patent Act, Indian Patent Act 1970 has 3 amendments. Amendments means changes they have made. After 1970 drafting of patents, they had made changes to improve the benefits for the patentee. So on 1995, what they have given is exclusive marketing rights for pharmaceutical and agrochemical products. In 2000, the term was increased to 20 years, and the definition of invention is inclusion of inventive step is the definition of invention they have included. So reversal of burden of proof on the infringer. If suppose I have patented, it was published. Someone is telling that it is my work. It is not her work. Like that, if someone is telling means they have to give the proof that whatever work done was before I submit, they have already done with proof, with record of proof, they have to prove it. Then only the infringement will be successful. So in 2000, what they have given is compulsory license provisions for food, drugs and chemicals were removed. So there is no compulsory license. And the right of patentee also includes importation. Then in 2005, what is the amendment has taken place is introduction of product patent protection for food, pharmaceutical and chemical inventions also. So from January 1, 2005, there are so many patents coming because of this product patents introduction. So many products are patented after this 2005. So they have given mailbox applications. If suppose the application was previously filed also, they can utilize the this product patent. If it is not come under a grant, till grant, this product patent can be done before 2005 filed application also. So what can be patented? It should be novel, useful and non-obvious. And it cannot be an idea, law of nature and scientific principles. Simple nature, Newton's law like that, and simple principle E is equal to mc square like that and all. It cannot be simple idea without any use, cannot be patentable. So if something you are doing and it should be patented means it should be novel and it should not be obvious to other persons skilled in the art, and it should be useful also. So why patent an invention? So it is giving a protection and recognition for the inventors, so that we can give license to an existing company, or we can ourselves start up a new company. So it can protect against imitators. Even you can see now in the market, some products will be there, similar color and pattern will be there, slight change in the name will be there for trademarks and all. So what they want to do is to confuse the customers that it is the original product. Like that, imitators, if they are doing that similar pattern means, we can do infringement. We can file a case on them, so that compensation can be claimed, or and further stopping the product can be done. So what are the salient features means? As discussed earlier, it is both product process can be patented for the term of 20 years, and both pre-grant and post-grant opposition can be done after examination. That means before grant also we can oppose some patent, and after granting also someone can oppose the patent. So the purpose of publishing the patent is whether someone is objecting that it is their work or not. And after grant also, we can raise up opposition. And this fast track mechanism is there. And the main thing is, in order to protect our biodiversity and traditional knowledge, if you are using any biodiversity samples, means we have to first register it. Then only we can able to apply for the patent, so that the Indian plants foreigners cannot patent. Like that, we have to register our biodiversity, and then only we can able to patent. So publication of application after 18 months, we can also, if we pay more, means we can also have early publication. So compulsory license to ensure availability of drugs at reasonable prices. So as it is patentable, it should not be go on increasing the amount. So we have to give compulsory license so that it will be available, the drugs will be available to the public with reasonable prices. So difference between publication versus patent. If we are doing some work in collaboration, sometimes our name will be there in the publication or not, we don't know. Because it depends upon the corresponding author, whether he will include our name or not. But in case of patent, all inventors should be included in the patent. And in case of authorship, the first person and the corresponding author only will be having major contribution. But in case of patent, all authors have equal contributions. All patenting inventors will have equal contributions. So this publication means future ideas can interfere with subsequent patentability. Sometimes in our publications, we might have given in future, we can do like this. So after doing that work, we can't able to patent because that idea we have already given in the publication. So it is available in the public source. So that idea, if we do, after completing also, it cannot be patentable. So we have to be cautious while giving the future ideas. But in case of patent, it is positive way. If you disclose the future ideas, we can prevent the usage from others using that particular idea. So it is protecting our rights. If you are disclosing some ideas in patent, means it will be positive. But if you are disclosing our idea in publication, means it is negative. So so only directly comparable results can lead to loss in priority in case of publication. And in case of patent, results from analogous systems also can lead to rejection. So in case of publication, what they will compare is plagiarism. Directly they will compare similar result if it is there or not. Then they will reject. But in case of patent, even in small words, it is given similar type of words given as per our idea, means it get rejected because it is obvious to normal person, skilled person. So that way it got rejected. So there is a difference between publication and patent of our innovation and inventions. And the best idea is to first protect your rights with patent and then publish, so that you will get double benefit. And then we can give our rights to any other company, or we ourselves can create a startup. So coming to the parts of a patent, first we should write the abstract as we do in a journal, and introduction, background of the invention, quoting our previous patents and all, we have to quote, and summary of our invention with figures and brief descriptions. If we are doing some gel, means we have to put our gel, what is the result, and it should disclose fully and how it was made and how it can be used. And claims will be dependent claims and independent claims. So dependent claims and independent claim means it is separate claims, and dependent claim means that for that independent claims, there will be some adjacent claims we can give in addition to protect our invention in more ways. So for example, we are using some formaldehyde 10% means. So we can give in future also any percent of formaldehyde used for this purpose will be protected. So like that we can give dependent claims. So this is the patent grant procedure. Filing of patent application. First it will be early publication if we pay more means. Otherwise, it is published after 18 months. Then we have to raise a request for examination. So after examination, they will send the first examination report to us. We should give our explanation for that. After giving that explanation, within 1 year, it will be grant or it is refused. Grant means the patent is granted for you. Refused means it is refused. So if it is grant means it will be published in the patent grant. And if there is any opposition to the patent before grant or after grant, it will be decided by the controller of examination, patent examiner, to decide whether to oppose, object or reference the patent grant. This is the overall procedure for filing the patent. So there are several patent offices in Kolkata, Delhi, Chennai, Mumbai, so that we can file the patent. So what is the scope of patentability under the Patent Acts? So under section 21J, invention means a new product or process involving an inventive step and capable of industrial application. So they have defined the invention as new product or the process involved in forming the new product. It should have some inventive step and it should have application. Then it can be patentable. So is it clear? So there are some exclusions under section 3. So under section 3A, frivolous inventions, that is invention with no use, cannot be patentable. And inventions contrary to well-established natural laws cannot be patentable. For example, machine which gives more than 100% performance. This is against the natural laws, so that cannot be patentable. Perpetual machines which will run indefinitely without an external source of energy, which violates the law of thermodynamics, that cannot be patentable. So section 3A excludes this two things which cannot be patentable. And section 3B, it is main thing, commercial exploitation or primary use of inventions which is contrary to public order or morality cannot be patentable. For example, gambling machine, which is a machine used to for playing to win money, cannot be patentable because gambling machine is not against the public order. And a device for housebreaking, which is against the morality, so cannot be patentable. For example, a device which is used for distracting people or harming the animals cannot be patentable. So likewise, for example, this can include this animal cloning also, because this animal cloning leads to health issues in animals, and moreover, it increases the aging. So it is giving some health issues, so it cannot be patentable. So section 3B insists that if the product causes serious prejudice to health or human, animal, plant life or to the environment, it cannot be patentable. So if the patent is giving serious health issues or problem to human, animal or plant life or to the environment, that product cannot be patentable. For example, embryonic stem cells. So it is after getting the embryonic damage only, we are collecting embryonic stem cells. So that cannot be patentable. And terminator gene technology, because it is arresting the plant generation itself. So that cannot be patentable. And biological warfare materials or device, weapons of mass destruction cannot be patentable. So these are the things which cannot be patentable. So likewise, the genetically modified organisms should not fall under 3B or patentable. That means it should not pose any problem in the should not pose any problem in the for the microorganisms or plants or animals or humans. Then only it can be patentable. So section 3B includes that safety of the biological material and environmental materials. So if it is safer, then only it can be patentable, although it is having some use. So section 3C means mere discovery of a scientific principle or formulation of an abstract theory, maths problems like that, formulations, and discovery of any living thing which is occurring in nature or any non-living substances occurring in nature. These cannot be patentable. Examples: Newton's law cannot be patentable, superconducting phenomena cannot be patentable, and property of certain material to withstand mechanical shock cannot be patentable because it is already occurring in as a non-living substance. And discovery of new microorganisms which is available in nature cannot be patentable, and discovery of natural gas or a mineral cannot be patentable. So on the section 3C, natural things occurring cannot be patentable, but it excludes patents on naturally occurring microorganisms cannot be patentable. But if the microorganism is genetically modified with some purpose of industrial application, can be patentable. If a novel gene, naturally occurring gene is not patentable, but a genetically modified gene would be considered patentable if it is new and inventive, having industrial application. If the gene is normally occurring in the organism, means it is not patentable. But if we isolate that gene and modify that gene, means it have some application, means it can be patentable. So earlier, in case of Chakrabarti, he has developed a genetically modified Pseudomonas bacterium, which has capacity of which is called a superbug, which has capacity of degrade multiple pollutants, hydrocarbons. It can be able to degrade 4 types of hydrocarbons. Naturally occurring Pseudomonas can able to degrade only 1 hydrocarbon, but he has developed, Chakrabarti has developed a new Pseudomonas bacterium which can able to degrade 4 types of hydrocarbons. So he has applied for patent for method of producing that particular bacteria and inoculum with inert carrier and bacteria themselves. But the patent officers rejected the claim for claims to bacteria themselves. They have rejected. He has again filed a case. Then after that, it got approved, telling that from that day onwards, in 1988 onwards, yeah, the modified microorganisms itself can be patentable. So after this, there is more improvement in the biotechnology industry, which has improved and saved lives around the world. And it has given a breakthrough for medical therapies and increased crop yields and renewable fuels. So Chakrabarti won the case by getting the claims to bacteria themselves also. Generally, process will be patentable, and the inoculum with some carrier can be patentable. So if you are using the inoculum with some inert carrier means it can be patentable. When he asked about the bacteria themselves, got rejected, but after going to the court, he has won the case. So now after that only, the genetically modified organisms can be patented. So in section 3D, mere discovery of a new form of known substance which does not result in enhancement of efficiency cannot be patentable. So for example, already the product is there. We are converting into some other form. It is not enhancing the efficiency also. That cannot be patentable. So we can't able to patent if it is not having some new enhancement in the property. If it is having new enhancement in the property means it can be patentable. So under section 3D, a new use of aspirin for heart ailments cannot be patentable. Mere new use of neem also cannot be patentable. So if you are mixing two components means under section 3E, it should have an enhancement effect. So just it should not have additive effect, it should have synergetic effect. That means additive effect means this paracetamol has one effect and brufen has two effect. One effect means 1 + 1 will be is equal to 2. That is additive effect. Additive effect cannot be patentable. But if it is having 1 + 1 is 3 means synergetic effect means it can be patentable. So we will expect only the result of 2, but in surprise it is having the result of 3. So synergetic effect can, if it is having means it can be patentable. So generally, normally person will be thinking of 1 + 1 is equal to 2 only. But into the surprise, 1 + 1 is giving 10. Then it can be patentable. So synergetic formulations can be patentable under section 3E. So section 3F means just mere rearrangements or duplication of known devices cannot be patentable. It can be protected under design, but it is not patentable. For example, bucket fitted with torch, both are already known. Umbrella with fan, both are already known. It can be design patent, but it cannot be designed, but it cannot be patent. Clock and radio in a single cabinet. Flour mill provided with sieving, that cannot be patented. So under section 3H, method of agriculture or horticulture cannot be patentable. For example, cultivation mechanism of algae, producing new form of a known plant, preparation of improved soil. These things cannot be patentable because it will prevent the farmers by using that product to grow the plant or to grow the algae to improve their soil. So that's why they have excluded this method of agriculture or horticulture. But agriculture equipments are patentable. So under section 3I, any process for medicinal, surgical, curative and diagnostic therapeutic treatment of human beings or animals cannot be patentable because it will prevent the doctors from using the technique to save the lives. So that's why these techniques are excluded from the patent rights. However, we can perform treatment on tissues or fluids permanently removed from the body can be patentable. An apparatus can be, instruments can be patentable, but the method cannot be patentable, which is used for removal of cancer tumor, removal of dental plaque and caries, and surgical process involved, and methods of vaccination and blood transfusion, and process relating to the therapy cannot be patented because it will prevent the doctors from saving the lives. So that these things cannot be patented, but apparatus can be patentable. So under section 3J, plants and animals in whole or any part thereof, other than microorganisms, but including seeds, varieties, and species, and essentially biological process for production or propagation of plants and animals is excluded. So biological process for production of, propagation of plants and animals, and except these microorganisms, other things will be excluded from patentability. So these are not, these cannot be patented. So for example, a new variety such as durum wheat type deposited at the seed depository cannot be patented because it will prevent the farmers from saving and exchanging the seeds. That's why it is not allowed. But what is allowed is if it transforms some new genes like Bt toxins to that particular seeds, means under Protection of Plant Variety and Farmers' Right Act 2001, this can be protected as transgenic variety. So this plant variety and animal variety cannot be patented, but it is protected under new transgenic variety. So coming to Dimniaco, who has invented a preparation process of live vaccine for bursitis, which is an infectious poultry disease. This is the process of developing a live vaccine based upon the microorganisms. So generally, this should not be patentable. So they reject, the patent officers reject the claims. But he has gone to Calcutta High Court, and at last what they said is they have developed the invention product which is vendable, that is, it is applicable and it is industrially usable, and it should improve the former conditions of the vendable product. Previously, it has improved it from the previous things, and it should affect the preservation and prevention from deterioration of the product. So thus, this product was granted, and this process also was granted, which results in curing the disease. So they have developed a process of preparing a live vaccine for bursitis against this infectious poultry disease. So this process can also be patentable as it is having some industrial application, that is curing the disease. So he won the case, and after this, there is revolution in the biotechnological inventions. And other inventions also excluded, like mathematical problems, business algorithms, computer programs is not patentable. And if it is connected to hardware, means it is patentable. And literary works cannot be patentable, but it can be protected under copyright protection. And mere scheme or rule, a method of mental act or playing games cannot be patentable. But if an apparatus was created for playing games, means it is patentable. And manner or method of expressing the information by words cannot be patentable. And IC circuits cannot be patentable. And falling within this Atomic Energy Act cannot be patentable. And traditional knowledge cannot be patentable. For example, wound healing property of haldi, that is turmeric, was known to the public. Traditionally, we are using for wound healing. That property of haldi cannot be patentable. Example, traditional knowledge of neem also cannot be patentable. But extraction process of Assad reactant from neem can be patentable. Under process patent and the product patent, it can be patentable. But simply as a haldi or neem, it cannot be patentable. So earlier they have raised the opposition against this neem act as a patent, and we won the case. So what are the stages? These stages already Srinath sir has explained you how to go and how to check and all, and what is the it will be updated in the website, how to process and what are all fees we have to pay. So first examination report, response, oppositions and all. So this is the overall stages of filing to granting a patent. First we can apply for provisional patent or complete patent. Provisional means we will have 1 year time, 12 months time to file the complete patent. So if our product is in the preliminary stage, means we can file as a provisional patent. And after that, we can within 1 year, we can file as a complete patent. And published, it will be published in the 18 months. And we have to give, within 48 months, we have to give for request for examination. And they will give first examination report. And within 12 months, we have to give the justifications. And this will lead to grant of a patent. And if there is opposition, means the decision of the controller will be there, and we can appeal also against that decision if it is not favor to us. So renewal fee also we have to pay. So coming to the biotechnological inventions, as a biological material, we can patent proteins, DNA, chemicals from microorganisms if it is isolated in a new form and it is having some industrial applications. And living organisms such as stem cells, bacteria, viruses, animals, and plants also can be patentable, and if it is something new in it. So methods and uses of biotech related products which can be patented are producing a protein and PCR amplifications and in vitro diagnostic techniques developed, in silico screening, preparation of process preparation of plants and animals, and making foods and medicines can be patentable. So what cannot be patentable means the treatment method, diagnostic method, screening methods cannot be patented, as I said before, because it will prevent doctors to practice. So patentable medical type claims means, for example, if you consider interferon, we can use it as medicine, and we can use it as medication for treating cancer also, and we can also use it as diagnosing cancer also. The concentration of interferon can be used as diagnostic method for the cancer diagnosis. So now in the current scenario, no patent in pandemic, because India and South Africa in 2nd October 2020 asked this World Trade Organization to allow all countries not to grant or any patent related to COVID-19 drugs, vaccines, and diagnostics for the duration of pandemic. Why means, if it is patented means it will be costlier and we can't able to save the lives. So there is a dilemma between what we have to choose, whether we have to choose money or lives. So which we have to choose is lives. So in order to save the lives of the many people till the pandemic ends, no patent in pandemic was landmark move started by India and South Africa for granting no patents or profiteering in a pandemic situation. So this is how, until pandemic is over, we should not protect the vaccines or treatment related to COVID-19. So no monopolies on medical tools in a pandemic situation. Even tools also, we should not grant patent so that it will be costlier and it will not be available to the public, as we need more and more tools and vaccines. We should not protect under patent rights. So what are all patentable inventions in biotechnology as a whole? So compositions such as nucleic acids, protein sequences, antibodies, small molecules can be patentable, and machines devices also can be patentable. And method of making the antibodies or method of synthesizing novel peptides also can be patentable. So compositions also can be patentable, tools also can be patentable, and process also can be patentable. So for example, we can isolate a nucleic acid encoding a gene. It should have some application, and novel polypeptides with some applications, and recombinant antibodies with some applications, and novel organisms which can be used for wastewater and sewage treatment. Novel vaccines can be patentable. Primers also can be patentable, and method of enzyme purification also can be patented. And plasmids, vectors also can be patentable. So according to the Indian Patent Act, microbiological process can be established as inventions, and it can be patentable. So process is patentable, and criteria it should follow is novelty, inventive, and industrial application. The biological material should be deposited in the culture collection. Under Budapest Treaty, what they are telling is, whatever the material which is to be patentable, it should be deposited in the National Culture Center or International Culture Center, so that it will be available to the public after the patent period is over. So Indian law does not allow patenting of animal whole or part. So for example, if you take Taq polymerase, means it is naturally occurring, but the purification we are doing from the Thermus aquaticus. So it is novel, and it is have application that is PCR. And recombinant form of Taq polymerase is available, so that it is genetically modified and it is useful. So the Taq polymerase isolated purified from Thermus aquaticus is novel, and it is having application for PCR, so that it is patentable. So expressed sequence tags, gene fragments, proteins, stem cells, SNPs, all can be patentable if it is satisfying the novelty, non-obvious, and usefulness. And it should have some written description. So gene inventions, these things can fall under claims, and we can patent the pharmaceutical product, treatment, screening method, and process of making the protein. Epitope sequences also, vectors, promoters, nucleic acids, and protein sequences can be patented. So the technology used is transgenic technology, knockout technology, antisense technology, siRNA technology, target specific expression, and gene expression profiling, expression promoters, gene constructs. These are the technologies which can be patentable. So other issue is even single genomic gene to be patented in several ways, as fragments, SNPs, peptides, etc. So this will prevent the knowledge sharing in the public. So it also raises social, ethical, and religious issues. Example, stem cell research. So stem cell research means, if you are doing, means it is having, because the embryonic stem cells which is taken from a embryo cannot be altered. It is ethically, it's not acceptable. So these issues are raising. So after solving these issues only, it can be patentable. So Product inventions means chemical compounds, microorganisms, formulations, apparatus, device, etc. can be patentable. And method of synthesizing process means method of synthesizing a compound, method for purifying or separating a compound, and even second medicinal use also can be patentable. So what not to do when considering filing a patent? We should not publish prior, even in article, press release, conference, presentation, poster, proceedings, everything we should not disclose our idea. And we should not sell our products before filing the patent. And we should not give lecture or presentation prior to filing the patent. And we have to seek patent professional advice so that we can protect our rights more. So we should file first before others do. So what is microorganisms? Whether it can be patentable? So it can be patentable if it is connected with some inert material or in a medium which is used. So what is the need for patenting microorganism? Means because nowadays there is commercial value for microorganisms in industrial and agriculture sectors, like biofertilizers and biopesticides. It is having advanced property application, and we can protect our rights so that we can able to earn money by protecting our rights, and so that we can know our knowledge. So issues, what are the issues involved in patenting microbiological invention? Means scope of the patent in the given time frame. So we have to in that particular time frame we have to show our proper microbiological inventions, and novelty which should be there, and relationship between the R&D and industry is not proper, and proper IPR knowledge was not there, and lack of knowledge of native places and loss of biodiversity also. So reproducibility of the invention is lacking, and relevance of convention on biological diversity. So as I said before, our biological material should not be patentable foreigners. So it is prevented. Likewise, if you want to protect our rights, means it should be first registered in the biological diversity. So as I said before, it should be deposited as per the Budapest Treaty deposition. So in 1979, Goldberg has granted a bacterium which kills mosquito larvae. In how means it along with the carrier, our patent was granted. Although it is a Bacillus thuringiensis, he has patented along with its carrier. So coming to the patent search, there are 5 different pre-patent search engines available. For example, Google Patents. So it is our top recommendation among the free patent search engines, and Lens, AE SpaceNet, PatentScope, and USP-TO. So why we need to do patent search? Can anyone tell why we need to do patent search? We think that it is novel idea. Then why we need to do patent search? Can anyone tell why we need to do patent search? First, we need to confirm that our invention, whatever we are thinking, is not done by others, or it is not available in the public network. Otherwise, it will be, if it is available, means it will reject it. So in order to save money, we have to search first, and in order to gain confidence on our invention. And if we search and if we get some points, means it will be easy when the first examination report comes, means we can able to reply back with confidence, so that the chance of getting grant of patent is more. So patent search is more important, and I will show how to search a patent. Is it visible?
Yes, ma'am.
So this is the Google patent search website, which we can go. We can do advanced search as well as normal search. So anyone want to do particular search, or I can do, if anyone is telling some search, you have any idea? For example, CEO combined with ZNO. Okay, nanomaterial. So how many results have shown? 6,620. So if you are combining, if you are utilizing some compound, we can give, what compound we can give? Oxalic acid. So how many results are there? It is just 611 results. So this 611 results, you can see how it has been utilized. So in combination, you can give glucose also. So how many results have been shown? 244 results. Okay. So if you want to specifically do some research, means we can do double quotation also. Because so 248 results have been shown. So then we can analyze whether our innovation is unique or it is already done. If it is already done, means we should not file the patent. So if it is not done, even see here, nano we have to include, right? So 253 results. Result in this. So here is, this is the process and apparatus to synthesize. Like that, we can see this 200 things, whether our product is unique or not. We can able to come to a conclusion by using this Google patent search, and there is advanced search also there. So best thing is you can search in Google patent search, and after searching this, we have to search in normal Google also and normal YouTube also, because our innovations, similar innovation should not be available in the public forum, even in Google or YouTube or any paper also, which is available to the public. So it should be unique. So if there is any difference or alterations in this preparation of nanomaterials, apart from their claims, means because we might have used different percentage, they might have used different percent, but in the dependent claims, what they might have given is all percentage, like that they might have given any percentage of glucose used, they have to protect it. So then we can't able to protect our rights. Okay, shall we see some how the claims were written? So this is the abstract. So abstract is telling antimicrobiologically active agent for building industry. This method some after abstract. These are the claims. So as I said before, there will be independent claims, and based upon the claim one, these are the dependent claims. Okay, so there will be one claim independent, and based on that first claim, there will be dependent claims based upon that. That they might have mentioned this percentage like that. So here they said alkali metals. Example, what they have given, Na plus or K plus. They might have used one, but they are giving this usage of the Ca2 plus, Ba2 plus like that. So they want to protect the other users from these materials also. Okay. And what are the results obtained? They have given the diagrammatic table format they have given. And at last they have given the claims. So what they are defining is background of the inventions and technical details, summary of the inventions and results along with the drawings, and they are showing the claims. Claims means what is their protection they want. Okay, so we can if anyone want to search anything means we can search it. Can anyone want to do some search? They want to do some patent, that particular thing, can do search. So apart from this, we can able to search in other websites such as Lens. So this is the result of Lens, and this is the result of eSpaceNet. It's giving 706 results, and this is the result of WIPO. We can use all the websites, or we can use one or two websites on the Google. And this is the USP Tubo search engine. So here we can give and all, so that it can be patentable. So any doubts in this? Is anyone having doubt in it?
No, ma'am.
Okay, to conclude, what we conclude is we can able to patent the microorganisms. In addition to this inert carrier also we can patent it, and sequence we can patent if it is having some purpose, and all the products like vaccines, enzymes, compounds can be patentable, and we can able to patent if but if we can't able to patent the animal cloning because it is causing some serious health issues for the animals. Or human cloning is not patentable because it is causing some health issues. It is causing harmful. So it is against the section 3B. It is against the rule of the government. So it cannot be patentable. So we can protect our biotechnological inventions if it is having some application. Even sequences also can be patentable. EST, primers can also be patentable. Enzymes, if we are doing some enzymes with new applications, means it can be patentable. No one should say that new applications, then it can be patentable. So thank you very much. If you have any doubt, you can ask me.
Thank you, ma'am. Participants can post their questions in the chat box.
Yeah, thank you, ma'am. Here's one I have one doubt, ma'am. Regarding the patent language, it is always English, which is the recognizable language for patenting. Because suppose if a layperson like a farmer, he wants to have, he has developed a new technology or protocol, like how can he make access of this patenting technologies as such?
So patent agents are there, so he can contact the patent. Even scientists also contacting patent agents only for writing or claiming. If farmers' rights, basically they will protect their rights for particular variety. mostly and a particular variety of hybrid they might have developed variety, they will be protecting their rights. So they can contact the patent agents so that they can protect their rights.
What about in other countries, ma'am? Because I could see in your on the Google patent search, Chinese language is being imprinted.
Yeah. It will be Chinese means they will be given the claims in both the language, English as well as the Chinese. So there it depends upon the country, what language. In our country, it is only English, not any other regional language like that. If you want to, main thing I want to insist is the patent right, although it is unique, where we are filing that area only we will get the protection. Suppose if you are filing in India means, in India only we can restrict. If the US people or UK people are using our same invention which is patented means, we can't able to restrict because we have filed the protection only in India. So if you want to protect our rights in all over the world means, first we have to file a international patent file application, and we in individual country we have to file the patent. Then only we can able to protect the rights, our rights in using our valuable inventions in other countries.
Okay. Thank you, ma'am. And there's one more doubt I have related to infant formulations or drugs. Is there any stringent conditions associated with the patent when it comes to infant formulations and drugs which is being developed?
Ma'am, infant formulations developed, the conditions will be, FDA will be giving the conditions, formulations and how it will be there. But in case of patent, we have to define the process of development of the infant formulations and the compositions and how it is unique. And based upon the animal study or clinical trials, how it enhances the growth. Like that, we have to able to justify.
Okay, ma'am, that's
Whatever
all.
our
Whether some stringent rules, extra enforcements are there with respect to our same patent law only applies. There is no specific constraints over the law.
Constraints in case of all products, they will have, if a pharmaceutical product means FDA approval has to be there. Like that, approval has to be there. So after approval only we can able to commercialize it. So if you are telling some compound which is having some, we should show the results with animal study and human trials. Like that, we have to show the things.
Okay, ma'am. Thank you.
And one more thing, if we are doing some patent and we are not following, it means for examination or not, then it lapse means we can't again file it again because it's already available in the public. So we can't able to again file it. So if you are filing means we have to process it properly until the grant.
Okay, ma'am. Okay, ma'am. Thank you.
Okay, ma'am. There's a question from Dr. Prem Kumar A. What may be the cost for patenting newly isolated genes?
Newly isolated
Genes.
genes.
Yes, ma'am. Yes,
What might be? Can you repeat the question?
cost? Yeah, ma'am. What may be the cost for patenting newly isolated genes?
The cost is same only. What we have to do is, if any gene means, we have to first deposit in the NCBA like that. Then it should have some application, industrial application. Then we have to file the patent as usual. The process is as per the website. We have to individual patent or institute patent means nowadays this colleges also comes under concession like individual patents. So they are not charging much, 1,500 something like that only. It is coming for filing one particular patent. So first we have to sequence it and we have to deposit in the depository, whether it's a microorganism or the gene, we have to deposit, and it should have some application, proven application. Then only we can able to patent. Without any application, it can't be patented. The application means that sequence what we are found is to detect some disease, which is not detectable in the normal way. So PCR amplifier primer we are designing so that the sequence of that particular bacteria was not known before, but we have designed one new primer which can able to detect that particular organism using PCR. So that primers can be patentable because it is having some application of finding that disease, which previously not known, because the sequence of the organism was not yet revealed, not yet fully sequenced. So we have designed a primer which can able to detect perfectly the disease like that.
Okay, ma'am. Thank you, ma'am. Now, I would like to call upon Sri Sharan from 3rd BSc Biotechnology to propose the vote of thanks.
Am I audible, ma'am?
Yes, ma'am.
Yes.
Good afternoon, everyone. I feel privileged to propose this vote of thanks for today's online national level virtual workshop on patents and intellectual property rights. Our special thanks to Dr. V. Bhuvaneshwari and Dr. Srinath Naganathan for being our guest speakers for today's virtual workshop. The sessions had shed light starting on IPR, the Indian Patent Act in research that protects our work and royalty, and it gave us more info about industrial property rights and their benefits. And it concluded with biotechnological inventions and the patent law that showed us how important it is to patent a product before publishing it. Thank you, ma'am and sir, for your valuable inputs. At the outlet, I would like to express my sincere
Thank you
thanks
very much
to the
for inviting
management.
me, and it is a wonderful session where we can able to interact with the participants. And sorry for some technical issues in between happened. Thank you very much, Dr. Shivaranjani and the management of Dwarka Das Govardhan Das Vaishnav College. Thank you very much.
Thank you, ma'am. It's no doubt that it's a great exposure to the students, research scholars, industrialists, and all the participants. Thank you, ma'am. Thank you so much. Waiting for your future endeavor.
Thank you, ma'am.
Thank
At
you,
the
Sri
outset,
Sharan.
now I would like to express my sincere thanks to the management, Secretary Sri Ashok Kumar Mundraji, and Principal Dr. S. Santosh Babu for providing us huge support and opportunities in our college to equip ourselves in all possible ways during our tenure in the college. We are happy to express our sincere thanks to Dr. M.D. Balakumaran, Head of the Department, for his tireless support throughout our department activities. My sincere thanks to all the students, research scholars, and faculty who have actively participated from various colleges and universities across India. And my general and heartful thanks to all the faculty members and participants of our department. I thank the Almighty for showering His blessings by making this event a grand success. I once again thank you all for joining.
Thank you, Sri Sharan. The feedback link has been posted in the chat box. Thank you, ma'am.
Thank you very much.
Thank you, ma'am. Thank you, ma'am.